What is the new way to avoid formal probate in California? Oh, we'll get into that next. Welcome back to the channel featuring the leading probate real estate team in all of California. I'm Brendan Moore, realtor, SAR Masters Club Life member, and certified probate and trust specialist by the California Association of Realtors.
And hey, I'm Bill Heyman. I am a licensed California professional fiduciary. I'm also a licensed California real estate broker, as well as I am a registered and bonded California legal document assistant specializing in probate and trust work.
Like and subscribe right now. Have a house to sell and looking to avoid the cost and headache of probate, trust administration, or even the petition to determine succession? Those services are included in our real estate listing package with no upfront fee, and sometimes no fee at all. We've helped families across California save thousands in costs and fees, and we may be able to do the same for you. Our contact info is in the About section. Please don't wait. Let's talk today. So what we're talking about today is the new abbreviated probate procedure for probate homes valued at less than $750,000 in California. Now, before that, that number was $184,500.
Yeah.
Am I right?
Yeah.
Am I right? Okay.
Yep.
Now we're talking about AB 2016. It was passed by the California legislature in 2024, which provided an additional abbreviated probate procedure for decedent's personal residences having a value at less than $750,000 at the time of passing. And that's important.
Yeah.
It goes into effect for anyone who passes after April 1st, 2025. Now, Bill, let's get into that, this, because this new procedure is something you're very much involved in.
Yeah, absolutely. It has a lot of pluses and some minuses, but it's nice and it's good because it allows a family to, when someone passes away, if it's their personal residence and it's valued at less than $750,000 at date of passing, it allows the home to pass to the family without having to go through the entire formal probate process, which is a great thing because it cuts down the time that you have to wait. But there are some requirements in addition to the couple that we mentioned. As I said, it has to be the decedent's personal residence at the time they pass. Now, from what I've read on this, that doesn't necessarily mean that the decedent had to be living in it at the time they passed. For example, a lot of times, unfortunately, maybe people will be transferred to a hospice situation that's outside their home for the last month or two of their life. Well, that residence that they lived in before the transfer to hospice is still considered their personal residence, and you could still use the procedure, I believe, in a situation like that. As we said when you started, the date of death value of the home must be less than $750,000. At least 40 days has to have passed from the date of passing before you can initiate this procedure. And this next one, which I think is really critical, is it appears that all the heirs, anybody who's got an interest in the estate, in the house, has to sign that petition, the initial petition to start the procedure. If they don't, there could be some problems. And those are the basic requirements in order to use this procedure.
Yeah, now there's certainly pros to this, and it probably sounds really good to people united to avoid probate. There's cons.
There are.
And when I heard about this, I thought, okay, well, that's great for some people, but it's a nightmare scenario for multiple reasons.
Yeah, it could be.
When there's real estate involved, for selling the real estate, that I could think of just on the real estate side.
Yeah.
Get into some of the pros.
Sure, and I have my list here. Well, first of all, it's a shorter procedure, which is nice. It's likely to take probably somewhere between 45 and 120 days to fully complete it, depending primarily on how quickly the particular court you're working with will assign hearing dates. And so if you've got a court like right now, Sacramento County is really good with hearing dates. You can get them 30 to 45 days out. But I have some courts in Southern California that I work with where you can't get a hearing date for 90 days, sometimes a little more. So whereas a regular probate, you're talking on average 12 to 14 months to complete it. So it is quite a bit shorter, which is a pro. There's less court costs because you have, number one, you have less hearing dates, less hearings, which every time you have a hearing, you got to pay a filing fee, which right now is $435. So there's less in costs, and there's some other court costs that you don't have because it's not a formal probate. So you save a little money there, that's for sure. It's a fantastic procedure, and I highly recommend it if all the heirs are cooperative and the plan is to not sell the home, to keep the home. If that's the plan, it's a great procedure, and I think you should use it, absolutely. And the other thing is, if you are using a probate attorney, it's likely that the attorney's fees will be less than what a formal probate costs. So those are kind of, well, one other thing too, there's less paperwork. Obviously, it's a shorter procedure, so there's less paperwork than a full-blown probate. But those are some pros that come to my mind about this procedure right off the bat.
Yeah, so I mean, those are some good ones. Now, so, some of the cons, and you, in a way, alluded to what some of those would be coming up. I'll throw in my thoughts on a couple of those. Well, once you get to them.
All right, no worries.
Sometimes, oh gosh, there can be all sorts of disagreements and stuff like that with family and probate when there's no will involved and intestate succession takes over. Sometimes it's not just you and your two siblings. It's maybe your sibling who passed away and they had kids, and it can go so far down the line. I've seen it where there's dozens and dozens and dozens and dozens of heirs.
Yep.
Let's get into the cons, Bill.
Okay, I have a pretty good list here. Well, one thing, you cannot sell the probate home during this abbreviated procedure. Whereas in a formal probate, you can sell during the procedure. But the reason you can't you can't sell during this procedure because there's never any what are called letters of administration or letters testamentary. Those are never issued. So during this procedure, no one is appointed to be legally in charge of the estate. That only occurs with a regular probate. So you don't have anybody that can really legally take care of anything that has to do with the estate while this procedure is in motion. So let's say that the probate home, there's an insurance issue. There's repairs that need to be done. Something happens where somebody has an accident at the home and there's a lawsuit. There's nobody who has the authority to act for the estate during this abbreviated procedure. Whereas again, with regular probate, there's ways to take care of that. Foreclosure. Oh my gosh, this is a huge one. And you and I, we get this relatively often. We'll get someone who will come to us with a probate home that is in foreclosure, and it may have a trustee sale coming up in the near future, and something needs to be done right away. With this abbreviated process, you can't do anything. No one's got authority to do anything. Now with a regular probate, you can start the regular probate. Your hearing date might be out there a little bit, but you can file what's called an ex parte application to get a special administrator appointed to handle everything that has to do with the foreclosure and the sale of the property. And that can be done within a few days after you start the probate. Again, you don't have that ability with this abbreviated process. So for example, let's say you need to probate a home and you're in foreclosure and you have a trustee's sale date that's coming up in 30 days. If you try to use that abbreviated procedure and your hearing date's 45 days out, you're out of luck. Whereas with a regular probate procedure, you can file the probate petition. The same day you can file the ex parte application for a special administrator. Within a matter of days, you can get that special administrator and you can get going on that foreclosure process and do something about it. So to me, that's a huge con. That's a huge con. Another one is all the heirs or anybody who has an interest in the estate has to sign that petition. So, Brendan, you and I have been involved in several cases where we're going to do a probate, help a family out, and there happens to be an heir who lives in the property and they don't want to sell. They don't want to get out. Well, if they won't sign this petition for the abbreviated process, you're kind of out of luck, and you're going to have to go the regular probate. Whereas with the regular probate, you don't need everybody to sign the petition. You only need the one who's going to be the administrator. So there's an advantage to that as well. One of the big ones.
This is a big one for me.
Yeah.
Big one.
At the end of this abbreviated process, the probate home is going to go from being in the name of mom or dad into all 4 names of the kids who inherited.
Or more.
Or more. Yeah, or more.
And there's often more.
Yeah, I mean, I had one particular case where I had 89 heirs. 89. But anyway, so let's say the home goes into the 4 kids' names, and now they want to sell. Now, every single one of those kids has to sign every single real estate document, every single disclosure document. That just complicates things tremendously. If one of the kids decides, I don't want to sign, you can't list the home, you can't sell the home. Now the kids who want to sell are forced into what's called a partition action. Got to hire an attorney, go through a whole nother court procedure. It's going to get expensive. It's a real pain, but that's what you have to do. So personally, I think that your safest bet is still to go the regular probate process if the intent is to sell the home. If you want to sell the probate home, I highly suggest you go the regular probate process.
Yeah, and getting back to this one, some of our audience might think, well, me and my siblings, we all get along. That's going to be fine. I'm telling you that even if that's the case, having 4 people sign the real estate documents where there's only even 2 spaces for signatures, it's hard to get everybody on board, because in real estate, sometimes I need signatures that day when you're selling the house. So I need to communicate with all these people like, hey, signatures now on this. And it's pretty easy to sign because it's a digital signature. But now some of our audience are thinking, oh, I have my one sibling who isn't so great at communicating. Maybe there's things going on in their life. They're unemployed, or we've had several where there's one incarcerated. Several.
Yeah. Or you've got the kids are spread out. One's in New York, one's in Oklahoma, one's in Texas, one's in California. And like you said, even though you've got digital signatures, sometimes, people who live way out in rural areas are not always easy to get a hold of.
I just thought of a scenario while you're talking about this. What if one lives out of the country?
Oh gosh.
When it comes to the grant deed, when you sell a house, it has to be notarized. You can't just send a notary to them. There's a process for that, and oh gosh, if there's a ton of heirs.
Yeah, I had a real estate sale not too long ago where the wife was living in Thailand. We had to jump through hoops to get that thing. It was unbelievable. But
yeah. But what you mentioned there, that if one heir is like, I'm not selling. Now, this is when I've talked with attorneys about this, they know that this is going to increase dramatically petition actions, which are not cheap.
And the thing is, with the formal probate process, if the family wants to sell, the property will get sold one way or another through probate. It will. Even if an heir objects to the sale, unless that heir has a ironclad reason that the judge is going to accept that the house shouldn't sell, which rarely happens, the house will be sold during probate one way or another. Yeah.
Let's get to another con here.
Well, one thing that people may not quite understand about this new abbreviated procedure is that one of the requirements is you have to get a probate referee to appraise the probate home as of date of death, just like you do during a regular probate. But it has to be done in order to prove to the court that the date of death value was less than $750,000. And in all reality, you need to get that done really before you file the petition and start the process. You want to actually file a completed inventory appraisal with the initial petition, so it's all done. Because what you don't want to do is you don't want to file the petition, get your hearing date, and the hearing date starts creeping up and you don't have the inventory yet. If you don't have that in, they're going to continue it out. It's going to cause delays. But one other thing, say you go out and have the probate referee do his appraisal and you pay, $400, $500, $600, $700 for that. And then all of a sudden, one of the heirs won't sign the petition. Well, you've likely just wasted that money on the probate referee. So there's a lot of cons to doing this new abbreviated probate procedure. I'm not knocking it, but I'm just saying that if you want to sell the probate home, if that's what you want to happen, I would suggest the regular probate process. I just would.
So I think here's what people need to do. If they're facing this and they're saying, I'm going to go with the simpler route, the new route, but maybe I want to see if I should go the other route. Well, one, it's very helpful to have a professional help you with these forms regardless. And if you're looking to sell the house anyways, Bill's going to go ahead and do all that work for you. And as part of our real estate listing package, as it is, whether it's this abbreviated procedure or a full probate. And Bill will look at your situation and figure out, which is the right one and help you decide.
Yeah, I mean, I can't make the decision for you, but I will certainly give you all the information I can and you make the decision. One thing that Brendan and I have agreed to is that with this new abbreviated procedure, if that's the route you go and at the end of it you want to sell the property and you list with us, we will do that abbreviated procedure at absolutely no charge to the client. So
it's worth reaching out to us. Anything else you want to add to this one?
I mean, I think we've pretty well covered it for now. I think everybody should keep in mind that this is a new procedure, so it's a work in progress, and there's probably going to be a few little bugs here and there over the next year or so until they all get worked out. But as I said, there are certain situations where I think it's great to use, but I know I'm beating a dead horse. If you do want to sell the probate home, I think it's smarter to go the regular probate procedure.
Yeah, shorter process. It can be less costly. If you're looking to keep the house, it's a great procedure, less paperwork, all of that. However, you can't sell the house right away. If you're facing some extreme circumstances such as foreclosure, it's not great for that. And it can create some serious problems if one of the heirs decides, no, I'm not going to sell. They're trying to deny other heirs their inheritance. And that can create a very costly process.
Absolutely.
And a number of other pros and cons there. But please reach out to us and we'd be very happy to help you. Please like the video, subscribe to our channel, and give us a comment, email, call, text. Our info's on the channel.